Hello and welcome to my channel. My name is Darren Woodfork and I'm an attorney here in Scottsdale, Arizona. And if it's your first time here, I'm an attorney in Arizona. I do personal injury work and I also set aside motions, old criminal cases here in Arizona also. And today I'm going to be talking about the difference between the new Arizona law that seals criminal records versus the old law that used to basically seal criminal records back before this new law here in Arizona. So today I'm going to be talking about the difference between those two laws. And they've came up quite a bit lately just because some of the requirements for the new law is pretty strict. So then people are kind of forced to go and file under the old law, but I'll get into all that before. So so the new law, as I've mentioned many times on this channel, is Arizona Revised Section 13911, and it's a new law that just started in January of 2023, and it's a way for people in Arizona who've been convicted in Arizona to file a motion with the court to get their criminal record sealed, erased from public view, from all the public records. Again, assuming the old case qualifies and it's not restricted by the law, but maybe 80% of the cases here in Arizona, 80% of the criminal cases will qualify under the law. And then you have to just worry about waiting the time period after the penalties and everything, after all the fines and penalties and everything like that is paid off. But that's the new law that was created back in January of this year. Now, the great thing about the new law, and I'll get into this, how it contrasts to the old law, was in the new law, you can literally, in the statute, tells you can go to an employer, a potential employer, or to a rental agency, or even a loan funding application, and you can literally write on those applications that you've never been convicted of a crime if your record has been sealed under this new law. So that's what's so groundbreaking about the new law here in Arizona, is that the actual statute, the language in the actual law, says that you can tell the people no, that you haven't been convicted of a crime once you've had this case sealed under this new law. So that's why it's so good. And also, it's good in the sense that it's the first law here that really erases an arrest or drop charges or even a not guilty verdict, or finding them not guilty after trial. It's the first method here that gets all of that erased from the books also. In Arizona now, if you get your case sealed, you can say, even if you are arrested and never charged with the case, you can get that arrest wiped off the books. Same thing if you are arrested and charged with a case, but then at some point the prosecutors drop the charges against you, that notation of all that process will be erased from the public records under this new law. And then finally, like I said, even if you were arrested, charged, and you went to trial and the jury found you not guilty and acquitted you of all the charges before, you would still have that process showing up in your record. However, now you can have the whole process erased. So now it's out of the public view, whether or not you, even though you were not found not guilty, it's going to be out of the public view, which is the way it should be, obviously, because if you were found not guilty, then there should be no record of the trial, the charges, the arrest. Should be no record of any of it because you were found not guilty. So again, that's what the new law, Arizona 13911, will rectify. Basically, it seals your whole record under those circumstances. So now that I've kind of went over the new law and why it's so good, I'm going to go over what the old law was before January this year. And because I remember I've been doing criminal defense work for 23 years, and I remember before this new law, we would file what's called a motion to set aside your conviction, and that was a different statute. It's a different statute still. It's 13905. We would file a motion to set aside convictions in Arizona for that under that statute, and I probably filed 25 or 30 over the years. A lot of times I'd tell my clients, if they were convicted of a small drug case or a DUI case or something like that, I would tell them, like, after their sentence, after they pay off their fines, after the ignition interlock device comes off, all that, come back to me in a year or so, and they'll file a motion to set aside the conviction. And that's kind of what, how I was involved in those cases. But again, I filed, like I said, probably 30 motions to set aside in the last 20 years. And that's why I knew this new law when it came in January. I knew why it was going to be so good, because I knew why it was different than the old set aside law. But with all that said, though, the biggest problem with the old law in Arizona, the motion to set aside law, was that once you filed it, once the judge granted it and said, I'm going to grant you the motion to set aside your conviction, it really wasn't set aside any conviction. What it was doing was set aside the penalties of the conviction. And so it didn't erase the charge off the book. It didn't erase the conviction off the books. All it really did, it was good though. It did, help the person. But what it did is it just basically, in the public records, it would, instead of saying the person was convicted of a crime, it would say the person's conviction was overturned or vacated or dismissed or some type of notation like that. But it would still have the case showing. And that was under the old 13905 set-aside laws. So you still have, when you go apply for a job, the employer would still see that you had the old conviction, but they would see that it was dismissed. And so that's what the old law did before this new one. And how I would explain to my clients is that the notation, or once the judge granted the motion, you could basically tell the employer or whoever you're applying to, you could say that your case was essentially overturned on appeal. And that's kind of how I thought of the old motion to set aside. So kind of to back up in big picture, in Arizona, there's basically 3 levels of court jurisdiction. You have the trial court, you have the appellate court, and you have the Supreme Court. And I kind of explain that in that, think of it as like a family. Think of it like the kids as a trial court, the parents as the appellate court, and the grandparents as the Supreme Court. And so if the kids make a decision that is wrong, the parents will say that what the kids did was wrong. That's the appellate court overturning the trial court. And then it can go all the way up to the Supreme Court, which is the grandparents in my analogy. But so anyway, so back when I would get the cases dismissed, or I get the motion set aside granted by the judge, I would say this is like having the appellate court tell the trial court that they were wrong and basically vacating the judgment of the lower court. And so that's what the motion set aside kind of was, because you would have, say, the car theft notation still in the public records, but then it would say that it was vacated after the motion was granted. So that vacated would be the same thing as if you took your trial level conviction up to appeal and the appellate court said you were right, the trial court was wrong, they're going to throw out the verdict, then you would have that the case would be vacated. And so that's what the old set-aside statute did for people. And again, it wasn't as good as this new law, but it was good enough to where somebody could go into an employer, and the employer can say, well, what was this case back? You had this marijuana case back 7 years ago. It says that it was vacated, and then the potential employee could explain, the facts of the case and why it was dismissed. And also, you could explain that you've been out of trouble for enough time, and you've done enough good things in society. You've done all these good things that the judge decided to vacate the case, decided to grant the motion set aside. You could explain all that if you had the chance. But again, none of that is necessary now if you qualify for the new law. You don't have to worry about any of that stuff because it's completely off the books. The new employer in my example wouldn't even see the old theft case, whatever. And so that's good. But also, also, there is a few advantages of the old law, even with this new motion to seal law. And even though, like I said, the biggest problem is that it still shows, your conviction still shows on the old law, just that it was dismissed, whereas the new law is completely off the books. Sometimes the person, and I came across this in the last 6 months anyway, when I've been filing these new seal cases, sometimes the person doesn't qualify for the new motion to seal law. And that's because the new motion to seal law, the qualifications are pretty strenuous in the sense that in order for the judge, well, even in order for you just to file the motion with the court, you have to wait certain time periods for you to be eligible to file the case. And I've mentioned many times before, and I'll leave it here in the cards. You have to wait 2 years for the smallest misdemeanor at all to file a motion to seal. You have to wait 3 years for a class 1 or for a DUI case. You have to wait 3 years to file your motion to seal. The class 6 felonies and 5 and 4s, I think it is, you have to wait 5 years to file it, and then the other ones you have to wait 10 years, like the 2s and the 3s, I believe it is. But nevertheless, one of the best things is that you don't have to wait the mandatory time periods as you do under the new law. And so, in theory, you could file a motion the day after you completed all your fines and paid all your fines and all that. Under the old law, you could do that. But as opposed to the new law, 911, you have to wait those statutory time periods. But under the old law, that you don't have to wait under the law. Now, in practice, what I would always do for the last 20 years is I would tell people it's a good thing to wait maybe a year or two after you're done with all your stuff, just so the judge sees that you've been a law-abiding citizen, and the judge is more likely to grant that old motion to set aside. And I would always give my clients that advice, and they were always successful. They always had the motions granted. So even though there's no standard time limits like there is in the new seal law, the old law, we still kind of waited a year or two before filing that. So, but anyways, that's the good thing about the old law, the 905 law, the set-aside law, is that you don't have to wait the statutory time periods under that. And then the other thing about it is you even if you're not done paying your fines and not done doing all your penalties, under the new set-aside law, under the new seal law, you can't file the motion until you've done all your stuff. You've paid all your fines, you did all your penalties, all that. However, under the old law, it wasn't mandatory that you had to finish paying off all your fines, for example. And so there's portions of the motion that we would file back then for the set aside. We would basically say there'd be a blank, and there would be room basically for you to explain why you haven't already finished paying your fines or paying your restitution, or have the interlock device. In theory, I guess, have the interlock device taken off your car. In the old motion, you were allowed to explain why you weren't done paying off your fines and your penalties and all that. Whereas under the new law, you can't explain it at all. If you're not done, you can't file a motion at all. But again, that's the good thing about the old law, that you have that ability to do that. And then again, it kind of goes back to the same there's some practical aspects of it too. Just like I said on the time period of waiting, even though you don't have to wait, you should wait just to get a better chance of having the judge granted. But even on the old thing, if you haven't paid off your fines, it's best if you were to do it, or if you only had like maybe one more payment to do. It's best to be closer to the end than anything. So when you file the old motion to set aside, you can tell the judge, I've been paying for the last 5 years. I'm almost done. I have 6 months to go. And then that would be more likely than not the judge would grant the motion to set aside. So anyway, so those are the two real big advantages of the old law in Arizona. But again, the new one, 911, is much better because, again, it wipes it completely off the books in the Maricopa Public Records database. So anyways, that's pretty much all I have today. If you want more information about the new law 13911, which is, again, probably the best law I've seen in 23 years of practicing law, you can take a look at this next video that I have, or it's an older video that I have explaining the details of the law by itself. So thank you for watching, and I'll see you next week.